legislative year. We have in our midst, colleagues, a group of precious Jamaicans, a group of senior citizens from the National Senior Citizens Council who are here. I presume you may be from all across Jamaica, I don't know, just the corporate area, but I want to welcome you all to the sitting of the Internal and External Committee of Parliament. Just to let you know, we are one of a few standing committees of the House that deliberate on certain subject matters and make reports to the full House for debate and decision on the matters reported therein. Hope that you find you find the sitting interesting and meaningful. And I gather that amongst you is the mother of Miss Facey, our legislative counsel. I glance up there and yes, welcome. I remarked to her that I see where her beauty came from, though she indicated that her father do play a part in her looks. Thanks again for sharing with us this morning. Just a matter of procedure. Visitors to the Parliament, whether this committees or the full House, you are expected to participate in silence. That means that you cannot actively participate by way of clapping or applauding or any audible sound. That's what is meant by participate in silence. So I hope that you will silently enjoy the occasion nonetheless. We'll see the smiles on your face. Members, we have a few accumulated minutes to deal with. We have from September 25th, October 9th, October 24th, November 21st, November 27th, January 8th, and July 16th minutes. We can do them separately or together, accepting the minutes and confirming them, and then we could take any matters arising that you might indicate you wish to have dealt with, which would be at item 6. So I'm going to put that we take all the minutes for confirmation, so mentioned at item 5. Those in favor? Those against? So those are confirmed. Matters arising from those minutes? Yeah. And now that takes us to matters arising at item 6. I see no response. Item 7. Colleagues, there's a draft report that has been circulated, as is the norm. When the report is circulated, we have a chance to comment and make any suggestion for changes therein. Are we satisfied with the report as is drafted, or is there anything that we would want to have amended? I am seeing no response, so I'm taking it, Ms. Brandon, that the report that you have prepared is accepted, and therefore we will be tabling it to the full House. And then we will obtain a date from the House Leader when it will be debated in the House. So we will then do the tabling. We're a little bit ahead of time now. You recall that we had scheduled for the Ministry of National Security, and Ministry of Justice to make a presentation as at items B and C that came out of our last meeting, but they are scheduled to come at 11, which is 37 minutes from now. Given that we are where we are on the agenda, I think given that they are not scheduled to be here from until 11, as we had agreed, I'm going to ask that we suspend the sitting until 5 minutes to 11. Thereabout, we reconvene. Does that meet with your approval, colleagues? On the other hand, I'd want to suggest for us to consider, before doing that, sorry, what is the next matter to be dealt with by the committee? Members? Yes, they are down to come at item B. Of course, they will be coming to deal with the question of the fishermen that we raised in the last sitting.
Perhaps you could dispose of that issue summarily. Well, for my part, Chairman, I am not of the view that this is a matter which ought to detain us. The matter is before the court in another jurisdiction, and any evidence which is taken here can be requested, any information, and to use either for the U.S. administration in a negative way or otherwise, or which is likely to prejudice the case one way or the other. And I believe that we ought to allow that process to work its way through before we embark on any full-scale discussion about because the shipwright agreement is something which goes back to 2015 or thereabout.
Earlier.
And I'm not sure that we're in a position to.
Well, I tend to have a different perspective, member. What I would be interested in, and one who raised the question, I also have some questions I tabled to the minister, not in depth, but just in terms of procedures in getting waivers in those instances. But in the case of the 4 fishermen, or 5, I think it's 4 before the courts, one didn't join. Huh? 4. Right. Plus, there's another one, 5th one that is not a part of that suit. My interest in it, member, is really to get to the fact of the timelines of activities. Because from where I am, you have some Jamaicans who are caught in this situation, and what has been the role of the state entities in the process. 1, from the point of being apprehended at sea. 2, the detention, the apprehension by the U.S. Coast Guard persons, and which occasioned the request for the waiver to what do you call it? To go on to the vessel and to detain the men, given the waters where they were by international law. And most importantly, to what extent did the Jamaican authorities pursue, follow up the matter to ensure that the rights of the Jamaicans that were in question were being protected or being observed according to the shipwright agreement provisions? For example, and what with my concern is when they were detained by the Coast Guard, from what the submissions are from the Ministry of Foreign Affairs, there are certain protocols that ought to be adhered to in pursuit of protecting the Jamaicans being held, because they are detained with the presumption of innocence until they are.
Chairman, I take the point you're making, but are we then going to limit the questions? Because we run the risk of going outside.
No, that is only where I want to go. I want to satisfy myself. For example, is that any surprise or trick question that I have? And that's why I feel comfortable to say what
would it
say it here.
Could I then ask that those questions which you say are limited in scope be sent to the relevant ministry and personnel, and that they furnish those answers to us, which it's a pretty sensitive matter, and I don't think our neighbors to the north will be very forgiving if we start doing and saying things which will offend them.
Well, don't forget we are a sovereign state.
Yes. But that we have to look at the practical side of it. Yes, we can talk about sovereignty all we want to, but
and as a sovereign state.
Let us remember that might still has some function in this place.
I hear you, colleague. Member Clark.
Thank you very much, Mr. Chairman. This very building that we sit in reminds us very well each time that we're a sovereign state, and we will never forget that, because we fought long and hard for that, Mr. Chairman. But at the same time, I want to agree with my colleague that might we sit here, and the questions that are going to be asked are going to be very pertinent and very sensitive. And though we may want to limit it in certain scope or areas, we run the risk of having too much information out there, and I would hasten to say that we may want to yield to the situation to allow the foreign courts to run their course. We are not going to throw it out, because we really want to get answers from our ministry, but just to be on the safe side and put it off for some other time.
If I may, colleague, the only problem I have with that, is that our seeking to find out, or our finding out, is going to be delayed indefinitely until that jurisdiction sees it fit to.
Not necessarily, Mr. Chairman,
not necessarily, but
not necessarily, because you as holding, we're in another cap in a different arena. I suspect that you could sit with the ministry or the minister and have some question but to really take it to the parliamentary committee, it might lend support to something that we might not be able
I just want to say, when I ask questions here, they're not only for my own benefit, but for the people I represent. And I represent an area that has a fishing village.
We agree with you wholeheartedly, sir. But we must, at some times, allow good sense to prevail in certain things.
No, all the time. Member Terrelong?
Mic check. 1 sec. All right. Thank you, Mr. Chairman. Just to indicate publicly that when I got the notification that the Ministry of Foreign Affairs would be called to answer questions as it relates to the detention of the fishermen, it caused me some concern as an attorney at law, simply because this is a matter that is being adjudicated or will be adjudicated in the courts in the United States. And it is important that we do not embark on a fact-finding mission here, because that might certainly prejudice the case in the United States. And take, for example, things that were said in the media about, human rights and violation and mistreatment, etc. Even the attorney representing the fishermen from the ACLU, when he gave an interview on Nationwide, he said quite clearly that, the Ministry of Foreign Affairs might not have been aware of certain matters through no fault of the government, but certainly as it relates to the communication aspect. But also he cautioned matters being aired in the public domain simply by virtue of the fact that we would not want to comment on certain allegations being made of mistreatment, etc. But certainly once there's a matter that is before the court, caution must always be exercised, because we might say or do things here that would prejudice that case. What is important for Jamaica to understand is that implicit in the Shipwright Agreement is that it preserves the constitutional rights of all Jamaicans, and that must be made very, very clear. It must also be very, very clear that as a government, we respect the rights of all Jamaicans and we promote and value human rights generally. It was very clear that when the waiver was given in October 2017, it was very clear that the waiver was given on the conditions that the fishermen were in good health. It was given on condition that the fishermen would be advised of their rights, and it was given under the condition that fishermen were aware that they could seek consular assistance once the detention to the U.S. was made. So certainly at all material times, once the matter came to the knowledge and purview of the Ministry of Foreign Affairs, certain steps would have been taken to ensure that the rights and liberties of the persons were protected. And as I indicated before, the attorney himself representing the person on behalf of the ACLU, he said that it was his belief that allegations of mistreatment or maltreatment might not have been conveyed to the Ministry of Foreign Affairs or to the Jamaican government previously.
I hear you, Member Terry Long. That's one of the reasons why we have the Parliament to have the agencies speak directly to us. So we can hear directly from them what is their account of what have transpired. So we'll take it from there. As I said, members, we have another 20 minutes yet before they come. Other things we need to decide as a committee is our next agenda item.
Well, perhaps a good agenda item would then be for persons to indicate what is happening with the Trafigura case then, because that is a case that involves certainly international borders, international jurisdictions, and since we haven't heard much about it, then perhaps that could be a matter that we could ask relevant persons, what is happening, what is causing the delay? I mean, just food for thought.
Yeah, I'll be glad to hear what it is. I don't think there's anything to be concealed, and whatever there is, just full exposure is welcome. And in the same breath, I want to ask the police about why this is happening with the CMU investigation and why no one has been arrested. So, that's food for thought. No, man, internal and external, that is national security, where corruption and so forth exists as a criminal activity. So the internal affairs element of the committee has some relevance there. And why Royal Reed has not been arrested yet. Those are pertinent issues that we could ask at the internal affairs committee.
So those are two matters.
No, I was only enjoining my colleague in terms of other things that we could consider.
So I'm asking a question now, Mr. Chairman. I'm asking a question now. Is it
your proportionality does arise, because we are talking about
Mike.
A matter which has been referenced by my friend, which goes back perhaps 10 years.
Yes.
And insofar as I know, the matter involving the CMU is a matter of weeks, because the DPP having said to the financial body that go and get some more information, I would think that enough time has not elapsed between the DPP providing that advice or guidance and for us to get a fulsome report.
As well as it might be the case that they have gotten the information already.
Well, if we look at the time which has elapsed between the Trafigura decision and now, it's by whatever measure one wants to use.
You know, recently, colleague, there's reported in the media a minibus driver breached the Road Traffic Act, and within days he was brought before the court, and a verdict was rendered, and fines were imposed within 1 week. So the same thing could be asked about the evidences with CMU and the Ministry of Education and Mr. Reid.
We're talking about peaches and apples.
You are so right.
Yeah, Mr. Chairman.
That is peaches, but these are tons of apples that we're talking about with
Mr.
CMU
Chairman,
and the Ministry of Education.
the evidence was right there. It was captured. What is happening with the next case that you are talking about is the fact that you have to investigate to find out what are the evidence. So it is.
I can assure you that if I were representing that man, he could not be convicted.
Well, he got the wrong lawyer as his in his defense. He could ask for an overturn of that judgment. We want to reopen that case, that traffic case here this morning.
Mr. Chairman, it is 11:15. Perhaps we could check if any of the agencies are here. Sometimes they do come early and they are outside waiting. So rather than waste any further time on matters not before us, perhaps we could just have a look and then we could
the order is going to look. And then we'll spend less time talking about why Royal Reid has not been arrested as yet. Some vintage, yeah. But the interesting thing, colleague, about Trafigura, it never involved any state funds. While Ministry of Education and no, a matter that has come to public attention already. Well, I think you have your own facts. You know.
Mr. Chairman, what was the indication from her?
No, she's
are they coming in or they're not coming?
They're going to check. They're going to check.
No, I mean, she was signaling to you just now, but you were so heavily detained.
By your colleague?
No, with matters that are salubrious.
No, your colleagues
and salacious and sensational that you perhaps missed the indication to her. I think she was trying to get your acquiescence if they should come in or not.
You should recall that you introduced the subject.
Should they come in or not? International related matters. I do believe she was trying to signal you if they should come in or not, though.
I know, given your experience with the HR manager at Petrodome, you're going to be careful as to what you defend there.
Are we going to have you started off so well. I was so proud of you. You started off on, you started off as a chairman of a committee and not as I don't know, what is his position in that particular, what is his position in the opposition's party?
Opposition spokesman.
No, man, his position, he's a general secretary or
chairman.
He's a chairman. Oh, my apologies. Yes, you started off as a chairman of this committee and then you segued into being chairman of a political party and getting all political and everything else. And it is, we started off, you even asked for prayer. And in that prayer, we spoke about being guided, by the Lord and everything else so that we could do matters in the interest of the country and be fair and non-partisan and non-political. And then you segued into your hat of chairman of a political party.
Colleague, let me just remind you, you are the one who led me down a certain path.
At international relations, sir, as it relates to this matter being the matter that you would wish to have foreign affairs being an international matter, sir. But colleague, that being said, sir, I appreciate that you did not get enough rest over the summer because I know you were busy with your back to school, but perhaps we could take the next 13 minutes so you could actually get some rest.
Well, I just remind you that you brought me down a path that you should not have taken me. And I think you regret it now.
Not at all.
Anyway, we are that exchange is in jest. Yeah, just a few are there. Come, colleagues, I'm going to just ask that we suspend the sitting for 10 minutes and resume after. So suspended. Members, we will now resume our sitting. We have representatives from 3 ministries, from the Ministry of Foreign Affairs, Ministry of National Security, and Ministry of Justice. I understand that the full complement from the Ministry of Justice is not here now, so we'll proceed and deal with Foreign Affairs, and then the other 2, National Security and Justice, at the together, then, or in consecutive order. Let me say welcome to you all from all 3 ministries. This is a familiar place for you all, so I know you'll be on your own quite comfortably here. And especially Miss Dan, I know is especially comfortable being back here. Don't mind me picking on her. She will take it in the spirit in which it is extended. Just to give a bit of context, Ministry of Foreign Affairs, the issue surrounds, as you would have been briefed, the case of the fishermen who were detained on the high seas by the U.S. Coast Guard, and the alleged treatment meted out to them during that period. And so members of the committee wanted to get firsthand from the ministry a sense of what took place during the period of detention period of apprehension and subsequent detention and leading up to their release. There have been much reports in the media surrounding the matter. As a member of the committee myself, one of the interests I had in the matter is whether or not the Jamaican authorities, namely the Foreign Affairs and later on the Ministry of National Security, that was involved in granting the waiver to the U.S. Coast Guard, whether we sought to ensure that the provisions of the agreement between the Jamaica and the U.S. was adhered to insofar as protecting the rights of the Jamaican citizens that were held. Bear in mind, ladies and gentlemen, that when one is detained, it is on the basis that they are innocent until proven guilty, and therefore all rights that that is provided for them would be observed and be adhered to by the different entities that come into contact with these Jamaican citizens. So that is by way of background why we have invited you here this morning. You have submitted a written report that we have, and I'm just going to ask you now to make any summary presentation of it to highlight any point in the report that was submitted or anything else that was not in the report that you wish to put before the committee for its consideration. So I know. So I'm going to invite Ambassador Gilbert Russell. Robert, sorry. Who I happen to know from a very long age.
Thank you very much, Mr. Chairman, and good morning to all members of the External Affairs Committee. If I understood give a summary of your questions, I think it was twofold. One, what happens to the persons during a period of apprehension and detention? And secondly, what guarantees were given or sought to ensure appropriate treatment was given during that period? All right. With respect to as you know, the process is a twofold one. One where when a suspect vessel is observed by the coast or partners, in this case the United States, they then would apprehend, the vessel and the persons on board would have been examined. A determination would be made if it is indeed a vessel registered in Jamaica. If that is confirmed and they have adequate reason to believe that the vessel and the persons aboard were involved in any way in possession or trafficking of drugs, then they would put forward a request to board and to search the vessel. So during that period then, clearly having caused the vessel then to come to a stop and to the persons, we expect that in a context where both our countries, because there's no specific information at that point that is conveyed about the issue of treatment during that period, but it is an assumption that in the process of making your determination as to whether there is good cause then to believe that there's a second process, then we would expect that persons would be treated with due respect in the context of both countries being party to international human rights agreements. The second tranche then would be where if it is determined or there is good reason to believe that persons have been involved in drug trafficking activities pursuant to the shipwright agreement, then a request now would be made for the waiver. So if in that context a waiver is granted after consideration by appropriate government authorities of all the variables, all the information provided, then the persons would then be in the custody then of the United States authorities. And I think it was this particular case relates to that period. With respect to the role of the Ministry of Foreign Affairs, we are largely the conduit for the formal communication. So we would have communicated to the Ministry of the National Security, and through that ministry to the Attorney General's chambers, the request for a waiver. Should that be granted, and of course we are not ourselves involved in that decision making, but should a decision be so made, in communicating that to the United States, we specifically cite in the not verbal that conveys the information several things. That the persons should be examined to make sure they are in good health, that the persons are given their rights, including the right to two things: one, to consular assistance should they so desire, that they have the right to legal counsel. So all of these things are included in the not verbal, and in this case, as in any other, we did just that. And just to confirm that we got confirmation, and we asked the U.S. in the not verbal to confirm that these conditions have been met, and we did get confirmation to that effect. Yeah.
Those three things, Ambassador, are the ones that I have interest in. The medical examination, you said that they give confirmation that the medical examinations were provided. How do we normally ascertain whether or not that confirmation is in fact so? Put it bluntly, people can say anything. How do we confirm? Because someone else is doing it. How do we normally confirm that these things happen?
Yeah. And Mr. Chairman, if you would allow perhaps other members of the team who may have better understanding of some of the things that would happen in a context of being at sea, they may be better able. But we are told that there are appropriate medical personnel who can do what we call a normal examination to determine then that person's, well, by sight, I suppose they would take certain vital statistics, blood pressure, those, but we don't know the details of what happens. Yeah. So.
No, it's not so much the details of the medical examination. For example, and looking at the report that you tabled on page 3, the 3 items in the second paragraph that you captured, access to consular representation.
Yeah. Yes.
Which would be Jamaican consular officers, meaning Jamaicans now ensuring that the provisions are being that are provided for are being adhered to. In the instant case, do we have a consular officer who would go and see these persons and seek to ascertain that, one, have you had medical attention, do you have access to legal representation, which is the other provision that you would have mentioned in your communication? Who is it that ascertain whether or not the confirmation given by the holding party is as presented?
Mr. Chairman, there may be need for clarification about the time periods. We're really speaking here initially about the time of the and before they are taken onshore to the United States. So they are at sea. They are still at sea. And then this is where the complaints lay about the treatment while at sea. So it would not be possible for us to have access to them while at sea. The request would be as soon as they are taken aboard, onshore, then they would be allowed to have consular access, but there's conditional if they so desire. Okay. So yes, if they so, that is under the Vienna Convention. Many persons sometimes, for various reasons, indicate no, you waive the right. We don't need that, because very often, if I might, people believe that their immediate need is need of legal counsel. But that's a decision of theirs. But where a Jamaican national determines that he would wish to get consular assistance by way of, if indeed there was no legal counsel, but we're also guaranteed that that would happen. But if there wasn't, then we would assist them in identifying, not to make the decision, but to indicate persons who would be available to take that kind of case. We would also, if they wish, be able to make contact with family to say, where they are, what's happening. That is the kind of assistance that we would be able to provide. But as I indicated, this would not be possible until they got ashore.
Instant case, so Ambassador, where, as you said, they were at sea at that time. When they came on land on shore, how long after they came on shore that our consular officer made contact with them?
Yeah. Regrettably, in this case, Mr. Chairman, there was a disconnect between the information that went to the consul did not go at the time, but it could, we don't want to speculate since this case is subject to litigation, but it may be a case where they did not say that they wanted to have the consular support. So in which case, the consulate, being this in this instance, the consulate general in Miami would not have been contacted. But we are not in a position to know, because I don't want to preempt your next questions, but in a context where we have explained that the consulate general, that is, did not come into contact with the 5 nationals until the point of their removal from the United States. Yeah.
I'm sorry, Mr. Chairman, if I may. Because my understanding from the ruling from the International Court of Justice is just that. The International Court of Justice, in its interpretation of the Vienna Convention, has said clearly that it is a personal choice. So the state cannot impose consular service on persons who have been detained at sea. They can't. It is a personal choice. What I know happened in this particular case, and Madam Permanent Secretary can confirm, is that there was written confirmation from the U.S. authorities that one, the persons detained were examined and in good health, and that they would have been advised of their rights, and this would have included the right to legal counsel and also to consular service. It is then a personal choice of the individuals to say, well, okay, great, now that you've advised me of my rights, I want to get the consular service, or they can refuse the consular service. And my experience in maritime cases also is that oftentimes, based on the allegations, persons oftentimes do not choose the consular service because they don't wish for their families to be notified, or they will actually say to the Foreign Affairs, do not notify my family because I do not want my family to so notified. But I think what must be made very, very clear at the outset of this community is that the Jamaican government respects the rights of all its citizens, and in relation to our international treaty, the Jamaican government has always advocated for the protection of the rights of its citizens and for the safety of its citizens. And so even when we speak of the ship rider agreement, implicit in that agreement is the preservation of the constitutional rights of every single Jamaican. And so when I've examined the case and I've looked at everything, it says so quite clearly that the Jamaican government at all material times, what was waived was the jurisdiction within which to try the men on the allegations of drug trafficking. What was never waived was the protection of their human rights, and that must be made very, very clear. So, Mr. Chairman, there are two things here. There is the waiver of the right to legal forum, the place where the case is going to be tried, where the allegations that have been made of drug trafficking, because you will recall that what the Coast Guards have said, the U.S. Coast Guards have said, is that they observed, what drew their suspicion was the fact that they observed men throwing things overboard which they believed to have been suspicious. So I make no declarations on the case, neither is the Minister of Foreign Affairs or the government of Jamaica. What we have said quite clearly is that there are allegations that must be proven, and we as a parliamentary committee, we must be mindful that we do not say things that would prejudice a matter that is before the court involving 4 of our nationals, because we want to ensure that they have a fair trial. So if we were to go on a fact-finding mission to say, well, yes, they were drug trafficking, or yes, they were abused and everything else and stuff, those are matters that a court of competent jurisdiction must determine. All we can say that these are allegations. So certainly, as it relates to my earlier point, it is the jurisdiction that is waived. And under the Act, this is an Act, the Maritime Drug Trafficking Act was passed in 1998. It was again amended in 2005. It was again amended in 2016 by the previous, it would have been piloted by the then Minister of National Security, and it would have then passed through the Senate by the then Minister of Justice. So this is 2016, and those amendments included for the waiver. So all this administration has done, between the decision given by the Attorney Generals and between the protocols taken by the Minister of Foreign Affairs, is to ensure that treaties, agreements that were entered into as far back as 1998, 2005, 2016 were adhered to, while at all material times making it well known that the human rights of our citizens, the human rights of our fishermen, all 5 of them, must be safeguarded and must be protected. And we had written confirmation from the US authorities that that would have been so.
Member Anna.
It's good when you can have a member that's so predictable. Mr. Chairman, I have a question for the PS, or several questions, but let me start with the first one. I've read your report. The concern I have, if it is that the law says they have the right to personal waiver, in your records, when you actually found out about the case, because from what it says here, you found out about the case from media reports, and you took the following steps to do a number of things.
I'm sorry, on a point of order, that is incorrect, sir. I believe what was indicated was that what they found was the allegations of abuse. That's a completely different thing. Not the case, the abuse. The abuse.
Member Terrell, the question was not directed at you. Have heard the chance to correct if there's a correction should be given. No.
The question comes from the committee, It's not them against us. We are one committee here.
Member Terrell, but one member speak at a time.
Information is incorrect. It's incorrect.
Just easy. All of us
this
are here.
Predictability seems to be bearing out
to
very much.
To get some information.
We must be fair to the civil servants, so I will always maintain that.
With respect. Explain to me, because sometimes things written in black and white, things get lost in translation. I'm not in a court trial. I too am trying to get specific information as to what really transpired. From what I understand from the report, the ministry found out about the men's disappearance from the media reports. What I'm trying to understand is, based on your report, you go through a series of chronological provisions in terms of what you say, but what I'm trying to understand is, when you found out about the case in the media report, what are the things that then trigger your office to make certain things, if it is correct that you're saying that the men did not use their obligation with the consulate? How is it then that the ministry can actually step in if the men waive their rights?
If I may, the lawyers may need to answer the question about waiving of rights, but just to clarify, Ms. Hannah, we became just aware of the case that have been brought on their behalf by the ACLU at that time. Yes, in June. We would had we made a correlation between the 5 named, well, there were now 4 men who brought the case at the time, this case of complaint of mistreatment. Had we been able to make the correlation then, we would have known that it related to this case of the Josette. So that's where the difference is.
I'm glad you said that.
Yes, that's
and the
where
reason
the
why I'm
is.
glad you clarified that is because if my memory serves me correct, and you can correct me if I'm wrong, Jamaica got the impression that the ministry was not aware of the 5 men out at sea.
No.
And the lawyers overseas representing the men basically said that the men were out at sea for a number of days. It was, when we heard from the minister, the impression was given that they were not aware. Is this so?
No. As the newspaper reports initially were focused largely on the fact that 4 persons alleged to have been mistreated, and so that was the focus of the report. It was confirmed that there were 4 or 5 Jamaicans bringing the case. The names did not immediately ring a bell to us, so we were now trying to see, search our records to see if we had anything in a consular context. That did not yield any results. And then as more information became available, and it was now brought to that they were detained in a context where they had been apprehended by the U.S., then we were now able to determine that clearly this appeared to be a case related to the shipwrighter, and did the search, and then we were able to make the connection because the names of the persons were now listed. So that's how
I would be correct in assuming that the ministry would not have known of when the men were detained.
No. Yes, we did.
How would you have been aware if the consulate?
Yeah. Oh, the consulate. No, that's a little bit different from the ministry.
That's what I want you to explain. Right. Because if it is that the men said they did not want consular services, was it when that statement was made, when they waived their rights, that the ministry was advised about it? Or did the ministry know once the men were detained? So did the U.S. security services, putting it bluntly or basically, call the Jamaican government to say, we have detained these persons? Was that call made? If so, was the government aware of it?
We would have been aware, when I say we, through the Jamaica Defense Force, to whom the very initial communication is made, that these persons, person A, B, C, D, and E, have been apprehended on a particular vessel. Yeah, so that's the first thing. We would have known at that point. Once approval is confirmed that the vessel is Jamaican, because it could have, 5 Jamaicans could have been on a vessel registered in another place. So it's only when it's confirmed that it's a Jamaican vessel that they would be given permission to board and to search. So once that was exercise happened, at that time we knew the 5 persons who were aboard the vessel. The next step of detention then would come after the government, in a case where, if and when a government gives approval to waive jurisdiction over the primary jurisdiction over the persons. So only then they would be considered then as having been detained. The first part largely, and the lawyers can clarify, I think is regarded largely of apprehension. But the detention then, in other words, they are now fully in the custody of the United States authority, would only come at that point. So this case relates really to that period. Yes, when they were detained.
My
yes.
clarification was along the lines of whether you knew they were detained, and you're
Yes,
saying
yes,
you knew they were
We knew
detained,
that.
but the information and the conclusion of the mistreatment was another time.
That's right.
Okay.
That's right, yeah.
Just following that exchange with you, Ms. Ambassador and Ms. Hannah. You indicated, Ambassador, that the Jamaicans will have the right to waive the access to our use of consular services. In the instant case, did they waive it? Just want to clarify.
If they waived it, well,
So there's a presumption.
we do not know. We
do
have
not
no
know.
reason to believe that they indicated that they want. If I might, Mr. Chairman, for the benefit of the committee, I say in any partnership, we're acting in a concept of good faith. And so I can cite for you the specific response, the 3 points I made initially, the conditions that were cited to the U.S., I can cite the response that we got from the U.S., and having regard in particular to the issue of their right to consular assistance. All detainees brought into the U.S. for prosecution under this multilateral called the MDLEA are informed of their right of consular access. If the Jamaican citizenship, in this case, choose to exercise this right, they will be afforded access to consular service officials. If they decline this opportunity, we will inform the government of Jamaica as requested. So we did ask to be told. I have to say that we do not have a record as to whether that information came back. So we may have operated on assumption that not having heard, they did not confirm that. So going forward, and as you would have seen from our report, we recognize that there are perhaps small gaps there. So going forward, these are some of the things we are seeking to close going forward. Yes. But there was nothing, even after the process was in and the men were returned, nothing triggered anything to indicate to us that we may have, in other words, not provided a service that was requested. And so we just want to be clear that we always stand ready once we are clear that our persons require, have asked for, wish assistance, to make ourselves available to provide it as best as we can.
Ambassador, one of the difficulties I have, even in our local situation, many Jamaicans are not aware of many of their legal rights. They don't know. And it cuts across all various socio-economic levels. In a foreign situation, and I represent a constituency with fishermen too, many of them might not know what you just told us. So I would want to assume that where you have a legal arrangement that provide for these services, what I expected to happen is that when a call is made by a foreign entity that they are holding these Jamaicans and they have ascertained that it is a foreign vessel, that sort of thing, that they and of course they will be held at sea and they'll be taken onshore at some point. One, which is the nearest onshore point that the foreign authorities intend to take them. Two, which is the nearest consular services available at that point where they are being held. Three, an arrangement that the consular officer seek audience with these Jamaican subjects within some prescribed time to make sure that the provisions entail that you spoke of earlier on in the agreement are in fact adhered to, knowing very well that most Jamaicans would not even be aware that they have right of access to consular service, nor do they have right to medical examination, or that they have right for legal representations in the jurisdiction. I start from that premise, right, that they don't know. If they happen to know, no problem. But just in case they don't know, as a state entity, I would have the responsibility to make sure that those provisions are in place. So I come to the question or to the issue from that standpoint, Ambassador. I saw Member Anna and I saw Anna taking that order, Terry Long, the question. But I just want to get your comments first.
Answer your question, Mr. Chairman, on whether or not we had some idea of where the persons, we quite specifically in our not verbality, and I can cite the words. The ministry notes that it is proposed to try the Jamaican nationals and the trial is relating to their detention for suspicion of drug trafficking. To try the Jamaican nationals in the state of Florida, which is one of the states where a Jamaican Consulate General is located. The ministry requests that the Consulate General Jamaica in Miami be notified in this matter, even if the nationals have declined consular protection. As we had said before, their response, they gave the response that they would. So we were quite precise as to what point of reference to advise of the wishes of the persons.
I just have a legal, I'm not a lawyer, Ambassador, but you had said earlier that you were aware when they were detained. The dates that are in your report, the 13th of June, when you first saw the media report, and then the ministry issued a press release, I believe, on June 15th. If you come further down in your report, one of the things that was very clear was that the United States didn't find anything on the vessel. They apprehended it on the suspicion of, this is what is in the report, Ambassador Sharon. I'm reading from the report, not from anecdotal evidence out of my mind. The United States reports that they did not find any contraband. The legal question I have is when the United States, in a diplomatic note on September 18th, 2017, almost 3 months after, asking the government to grant a waiver of jurisdiction. This is on page 2, final paragraph of your report. Yeah. On the strength of its reported findings of the search of the vessel, the United States government formally requested by diplomatic note of the 18th of September 2017 the granting of waiver of jurisdiction by the government of Jamaica over the vessel, the cargo, and the persons aboard. The legal question I have for you is, in your explanation of waiver, etc., this was 3 months after. Right.
Just for clarification.
Right.
They were initially apprehended on the 14th of September, and this is the 18th, so it's just a few days, not months.
Okay, so
yes.
Tell me about the dates, the previous dates, in terms of the detention, in terms of when you were aware, etc. So they were 3 months out at sea. The reason why I'm asking you these questions, Ambassador, right? The Foreign Affairs Ministry became aware through print and social media of a case filed in the United States District Court of Columbia. This is in 2019. Just explain the chronology of the dates according to your report. And because the gaps that you talk about are also coming out in the press, in the media, in the report. Just explain for me, personally, the chronology as you see it.
To keep, as you say, as simple as possible. So on the 14th of September, these men were seen, and something doesn't look quite right. Let me just put in layman's language then. And they ask us to confirm whether this vessel is of Jamaican registration. That is done through the Jamaican Defense Force in consultation with our ship registry, MAJ, and so on, fishing people. That is done. It is confirmed that, yes, it is a Jamaican vessel. They then ask us for the permission to board. When they board, they report that they have found X, Y, or Z are indications that, yes, the vessel was being used for, the persons were involved in, yes, so that's what happens then. September 18th, they felt that having done their boarding and their search and having concluded that there were some good reasons for suspicion, they then asked for the waiver, yes. No. The waiver was done sometime in October 9th. If you turn to page 3, the second paragraph, yeah. Yes, so it takes time because government wants to make sure it looks at all the variables before, yeah. So it was done in this case, yeah.
All right, so Mr. Chairman, just to be clear, and I'm not going to be snarky or rude because I know better, but there's a clear misunderstanding of the critical facts of this case by the member as is directly visible or ascertainable by the questions being posited. So what is clear is that at all material times, and this is for the media, at all material times, the Jamaican government was made aware of the suspicion as relates to the vessel known as Josset, that the U.S. Coast Guards observed the vessel, certain matters drew their attention to it, they boarded, contact was made through JDF, Ministry of Foreign Affairs, etc. That was all done in September when it happened. This is 2017. By October 2017, having done the due diligence, etc., and based on the maritime drug trafficking laws in place in Jamaica, 1998, again amendments being made in 2005 and 2016, the government proceeded with the agreements in relation to international cooperation. One has to remember, Mr. Chairman, that the Jamaica maritime space is some 240,000 square meters. It is an area that is about 5 times or 25 times larger. I think it's 5 times larger than our physical landmass. We must operate with a spirit of cooperation with our international partners within the region of Latin America and the Caribbean, which is what we fall. There is absolutely no way Jamaica can protect our borders solely or monitor whether it's drugs for trades or drugs for guns or whatever kind of illicit activity that happens out at sea. I know, Mr. Chairman, allow me, please. You allowed Member Hannah.
No, on a point of order.
What's the point of order?
Yes. You know that in the standing orders, members of the executive are not allowed to be on the committees, and the rationale for it. The rationale for it is that the executive don't come to the committee to defend the executive.
I'm not a part of the executive, sir.
No.
I'm not a part of the
point
executive.
I'm raising.
It's not a point of order, sir, because we've discussed this already in several committees, and you're aware. You're aware, sir.
Mr. Terrell, I have not
all
finished.
The exceptions have been
Mr.
made.
Terrell,
all the exceptions have been
you
made.
Can't
You're
along.
doing this to try and shut me up, and it will not work. So I will proceed with my question.
No, the same way you didn't shut up about the HR manager at Petrojam.
There you go. How typical. Right. You draw for the salation.
Same way you be.
Sir, you are the chairman of a committee. Conduct yourself accordingly.
On a point of order, I just have a clarification. Ambassador.
I'm sorry, I'm not finished, Mr. Chair. I'm not finished.
I'm not
finished. No, but I'm not finished. I'm not finished, though. I did not interrupt anybody else when they were speaking.
Go ahead, Mr. Terrell.
I will not. No, I'm not speaking.
Mr. Terry Long, you come here with this habit of trying to railroad the proceedings to protect the government each time.
And I'm the one that is speaking, and you're trying to railroad my comments, sir, with the grace of respect, Mr. Chairman.
We are here as members
Mr.
of
Chairman,
to ask questions of the agencies.
I'm here as a member of Parliament as well. I'm not a member of the executive. I do not sit in cabinet. And you are very well aware that the point that you raised...
Read the Constitution, you're a member of the executive.
It is irrational, sir. I will continue. Thank you, sir. So, Madam...
Until I determine that, no.
Madam...
Mr. Terrell, understand, you are not chairing the committee.
And you cannot detain me from not speaking to the committee members.
You are not chairing the committee.
And I'm not finished, sir.
And the proceedings are subject to the chairman's
also, the chairman chairs the committee. The chairman does not dictate or spend so much time questioning civil servants who come here, sir. They don't. You chair the meeting, so you take and we continue.
Ask the question and conclude.
I was aware that I would have. Yes, so the spirit of cooperation with our neighbors. And so the Maritime Drug Trafficking Act from as far back as 1998, again as I indicated, amended 2005, amended in 2016. It sets out areas of cooperation. And so the nation must understand that when the Ministry of Foreign Affairs sets out quite clearly to the U.S. authorities, these things must be done. The rights of our citizens must be protected. They must be in good health. They must be advised of the right to consular service or to legal advice. When the U.S. authorities write back to Jamaica written confirmation that yes, they're in good health, yes, we've so advised them, yes, they are aware. It is from a diplomatic standpoint, every single principle of international relations and diplomacy, and in accordance with all the treaties that we're a part of, it would be foolhardy and a breach of diplomacy and a breach of treaty obligations for the Ministry of Foreign Affairs of the government of Jamaica to then say, well, we are demanding specific proof. We are putting the test because we think that you, our neighbors, that you are liars. The treaty does not allow for that. And so having received the confirmation from our partners, these are our partners, that the rights were respected and everything else, as I stated earlier, what was waived was the jurisdiction question as it relates to where would the men be tried based on the allegation of drug trafficking. The human rights of our citizens were never waived, and that was confirmed by the U.S. authorities. What the member also did not talk about, this whole nonsense about 3 months and everything, that is again fallacious. It is completely inflammatory. In 2018, the men were deported from the United States. When the Consul General spoke to them, no allegations were made whatsoever that they were mistreated, that any rights were abused. Nothing at all was communicated to the consulate in Miami. When they came to Jamaica, again, nothing was communicated to Jamaican authorities that they were mistreated, that they were abused, or anything at all. The very attorney representing the men, Mr. Stephen Watt, the very attorney representing the men, indicated quite clearly that he has no reason to believe that the Jamaican authorities were made aware of the abuses that the men now allege prior to the ACLU having filed the court case. So even the attorney for the men is saying that the government did not know about the abuse because at no point in time did the men communicate any abuse either to the Jamaican government directly or to the consulate in the United States. So one has to be fair when one is dealing with these matters.
Thank you, sir. Member Hannah.
Jamaican people have a saying, Mr. Chairman, sometimes you have to play a fool to catch wise. So I will continue asking my questions. Ambassador, the reason why I'm trying to get some clarification is because of the gaps. Because one of the things that the attorney actually said on June 20th is that they were a little concerned that the ministry was now blaming the family members for having not reported the men missing. It's a report in the Gleaner of June 20th. The minister herself said she was not aware of any mistreatment. I asked you my first question. If the ministry was made aware that the men were detained, you said yes. You were made aware that they were detained in September of 2017. And various legal obligations were given, they were boarded the ship. In terms of understanding when they were detained, waiving the jurisdiction, because Jamaican people want to understand it, right? If the men said, look, we don't want our families to know, does the ministry have an obligation, because they knew when they were detained, they knew 2 years prior to when, well, a year prior to when they were deported, that they were detained. Does the ministry have an obligation to at least notify their families, whether it is the Ministry of National Security or the Ministry of Foreign Affairs?
If I may just answer the two. Oh.
To the ministry, not to you. Go ahead, Ambassador. Colleague. No. When the question is directed at you, you can answer. Not you.
Mr. Chairman, with all due respect, you're having a conflict of interest where you're sitting now. Is either you're going to give up the chair and allow somebody else who has logics to work with it, sir, or something else, but you can't be making your statement, quarreling with everybody, as if that's not the job of a chairman, sir.
That's your opinion.
Chair, make the member and a chair, and then you can get to deliberate and cuss all you want to. And Mr. Chairman, you continue to behave in that way and allowing the general public to believe that the government members are against certain things. We are not. We want to get the same information.
You can answer the question. Go ahead and answer the question, ma'am.
Go ahead, she asked you to answer the question.
Thank you, Mr. Chairman. No, I think we are happy to answer as much as we can, as much as we know, to be helpful to our people, if the outcome of our discussions will be helpful going forward. That's the way we see it as public servants. On the first point, Ms. Hannah, on the issue of blaming the family, I don't think that at any point, I mean, and read your reports, we have to be very careful. At any point in time, blaming the family for not reporting the men missing, we would have lamented if indeed they did not. You will see that it was several weeks after we were asking various arms of the police, the marine police, and whether they had any reports of the persons missing. The NIB ultimately, some long time after, came back to say the family of the captain one person had said that reported he was expected to return by X time and they hadn't seen him. So that was, we know how a report was in fact made, since the reports it was given a general thing that all 5 men's families were reporting them missing, but that was clearly not so. Just one report was made. Okay? So that's to clarify that issue. You speak to the obligation that we have to make contact with them. No, we don't. Unless the persons have clearly, and I don't want to speculate in this case, but just to speak of our experience in the past, very often we find that where our nationals come into, let's say, trouble with the law, particularly of a third party, they don't want family to know. Sometimes they specifically share that with us. We can't say what were the reasons for this happening, and we don't want to speculate. This may well come out in the litigation process that is ongoing, and we hope that at some day, at the end of all of this, we will be able to have our own one-on-one conversation with them to share heart and heart what was their experience, and perhaps to answer why it is that at no point we became aware of, even after the fact, to say, this is what happened to me while I was in U.S. custody. Or even if while they were now imprisoned, incarcerated, there are after the trials and so on, how did things go? We ask these questions. So we really want to know what happens to our people. But we won't be able to do that now until all the process is through. So that's where we are in terms of our being in a position to have interaction with them. And as we further indicated, when the names came to the attention of the consulate, we weren't asked at one time for 5 travel documents for these 5 persons. So it's one here, later in the day another. It was spread over days separately. So we wouldn't have been able to make a connection that, all of these persons were related to the same case. So it's after, as you say, after the fact. Now we were asking questions, and our officers even interviewed them, because you have to be sure that you are repatriating Jamaicans. So even in that discussion, they didn't say anything, but they may be having good reason, the feeling that's not the time then to say anything. And regrettably, no, we're not able to do it.
Ambassador, I really want to thank you. And Mr. Chairman, if I may, I've been representing people for 13 years in this House. A lot of times the people who get into situations like this are not lawyers, neither do they have copious notes, neither do they read cases from the International Court of Justice. They really need honest answers of what actually took place, because they too are seeking answers. So if a mother, for instance, has a child who was lost at sea and does not hear and perhaps presumes the child dead, at least from your answer a while ago, they would understand that once the child is 18, the child can actually waive their rights. And I think it is important for the Ministry of Foreign Affairs to give detailed guidelines, especially now with things like ICE, especially with a ship rider, to put things in perspective so ordinary Jamaican, everyday people that we represent have a basic understanding of what their rights are so that they can act on it. Thank you.
Any other question for Ms. Ambassador? Okay. I'm now going to invite the Ministry of National Security.
Chairman, are you going to release the
yes, I want to, if you don't mind.
Very well, sir.
If we have any further questions for. But of course, as is usual, Ambassador, you and your team are welcome to sit with us. But if you have to go, we can release you.
We believe that it could be helpful, Mr. Chairman,
Sure.
our presence
Yes.
in the PS. What's
Yes.
it's the same case, and it's
Right.
it's sometimes
Makes
hard to
sense.
divide the line between their role and ours.
Yeah. Yes.
With the line of answer that respond that Madam Ambassador Gilbert Robert just give, is it that I'm understanding that in the case of the Ministry of National Security, when questions are asked or posed to them, that at any given time the Ministry of Foreign Affairs can
Yes.
and we can re-question?
Yes. That's one of the basis on which we also agree to stay. No, I was.
May I?
Yes, PS.
Okay. Morning again, all, Chair and members. Let me just take the opportunity to introduce the team. You may know everybody, but it's always good to be refreshed. So with me this morning is from the JDF, Commodore Wies Gorman and Major Deans. From the Ministry, Central Ministry, we have our Senior Legal Officer Simone Walker McFarlane, our Chief Technical Director Ron Richards, and the members of the Legal Office as well, Paul Bailey, Mr. Neil Beecher, and a member from the Protective Security Unit of the Ministry that focuses mostly on the physical security matters, Ms. Samantha Allen, and myself. All right. So I just wanted to open by stating, having listened to our colleagues from the Ministry of Foreign Affairs, we also took note of the media reports in relation to the matter, and our report has been submitted to you, outlining the processes involved in the waiver of this jurisdiction pursuant to the Maritime Drug Trafficking Suppression Amendment Act. At all times, the Ministry, as you know, we were operating in the ambit of the legislative framework, and we're guided by the advice of the Attorney General. So we operate with our stakeholders, inclusive of the Ministry of Foreign Affairs, but our Ministry Central, our stakeholders, our main players, is the JDF. The Ministry acts when we are formally advised, once we receive a formal notification from the Ministry of Foreign Affairs in the form of a diplomatic note from the requesting state. And we're guided by Section 20 or subsection 5 of the said Maritime Drug Trafficking Act on the legal advice of the Attorney General. In this case, the Minister was guided, we advised the Attorney General of the issues of the case, and it is therefore left on the Minister, in the interest of security, defense, international relations, or essential public interest of Jamaica, or in the interest of justice, for this decision to be made. And in this case, he outlined some conditions upon granting the approval for waiver, which included the confirmation we received that the 5 Jamaicans make contact with immediate family members to notify them of their whereabouts. So that is in essence that I wanted to state. Any further questions that we have in terms of what happens at sea and the actual notification that takes place once the event is taking place. It goes straight to the JDF. The Commodore Wiz Gorman will be able to give you more detailed responses. But the ministry acts when we get that diplomatic note from the Ministry of Foreign Affairs. And our role ends, so to speak, when the advice, when the note or the letter from the minister, the waiver from the minister is given, we send back to the Ministry of Foreign Affairs.
Commodore Gorman. I got the name right?
Yes, Mr. Chairman.
Okay. Just to briefly clarify, when that information comes to you from the foreign authorities, normally what time it takes for you to able to have a response ready for them? The request is made for a waiver in respect to the vessel that is detained. Normally what obtains? That's essentially my terms of time.
Okay, Mr. Chairman, just to clarify, the request does not come to the JDF for a waiver. The JDF, under the Act, is designated as a central authority to effect the Maritime Drug Suppression Act, which is the relationship with the United States, commonly known as a shipwrighter. What occurs is if a U.S. vessel intercepts a vessel that is suspected to be a Jamaican registered vessel or claims to be a Jamaican registered vessel, they would ask us to confirm that registry. And there's a prescribed form that they use to do that. And we would then, so the time frame to do that varies, because the databases that we interrogate to confirm registry lies with different agencies. So it could be with the Maritime Authority, or in most cases for fishing vessels typically used in drug trafficking, that would be the Fisheries Division. In some cases, the vessel is not registered at all, or we are unable to confirm the registry. But if the persons on board that are intercepted provide Jamaican identification, then we accept that as them being Jamaican, and that would give us jurisdiction over their disposal.
Member Anna.
I don't know if Member Terry Long has any questions first. Do you?
You're far too kind. Please, go ahead. Beauty before predictability.
Thank you very much. One of the things in the report says that there was no contraband found on the vessel, and then the vessel was destroyed. Based on your intelligence, can you just provide to the committee, if it is, it's in the report from the Ministry of Foreign Affairs, on the second page, page 2. Although the United States notification indicated that no contraband was found on the vessel, the further observation was made that the men were intercepted in a known drug trafficking area, and that there was an absence of any fish gear or equipment to substantiate the claim by the master of the vessel that they had been fishing. Following the search, the vessel was destroyed in the view of the danger it posed to the navigation in the area. So the question I have for you is, if it is intercepted, what is the conclusion to give the waiver? Let me ask it another way. Was the intelligence given to the Jamaican government that no contraband was found on the vessel at the time?
Ma'am, I can speak to the information that we received. In respect of requesting the permission to continue to board, the U.S. Coast Guard provided information that this vessel was identified, it was tracked for 45 minutes, it was observed throwing bales overboard, and that was the basis on which, having confirmed the registry of the vessel as a Jamaican vessel, that was the basis on which the JDF Coast Guard gave the U.S. Coast Guard platform the permission to continue the boarding.
The member mentioned in terms of the vessel being destroyed. You can correct me if I'm wrong. How do you pronounce where Miss Gordon? Sorry.
Weems.
Weems. Yes, thank you, Madame Weems Gordon.
Gorman.
Oh, Gorman. Thank you. Am I correct in that standard as it relates to international maritime safety? If a vessel is not able to be towed or based on certain dangers posed to maritime traffic generally, isn't standard maritime safety protocol that vessel would have been destroyed? It's not a question of malice or ill will, etc. It's just a question of safety to other marine vessels, marine traffic generally. That's standard protocol.
That is a correct statement, sir.
Thank you, ma'am.
Commando, the vessel is destroyed. JDF gets intelligence that there's contraband that was thrown off board. Is it incumbent on us to see that footage, or we take it as given from the U.S. government that that actually did happen?
I would imagine that we're in a let me answer it this way. There are different types of platforms that would do an interception. Not necessarily all the platforms will have the capability to record or provide footage. Where that is available, it is generally shared with us. But we do accept the information on the good faith that it is meant to be accepted on.
Perhaps I can ask my learned friend to my right. Would that be considered hearsay in a court of law?
Mr. Chairman. On a point of order, Mr. Chairman.
No, hold on. I'm asking my learned friend.
On a point of order, Mr. Chairman. Before my colleague Hannah came to the meeting, we had taken a decision, or we took a decision not to go too far with the line of questioning, because there is still an ongoing case in another jurisdiction. We took that decision, Mr. Chairman, and I would hate to know that we are going down a pathway that is going to jeopardize and create a bias in some way against the very same people that we are saying that we are trying to serve and protect.
Is that a legal assessment?
I'd like Mr. Terrelongus to answer that.
Yes, and I'm sure the Jamaican public would like for me to answer, and that they appreciate the benefit of having a trained attorney at law on the panel who actually understands maritime issues.
Wow.
So it would not be hearsay, simply because, and again, I have great respect for what Member Clark has indicated, because quite frankly, at this particular juncture, when the matter is tried before court, the officers from the U.S. Coast Guard, they would be in court and they will say, I, Commander or Lieutenant or whatever his rank or title is, I saw these things being jettisoned from the vessel. So he would actually be speaking to things that he actually saw. So it would not be hearsay. And again, Mr. Chairman, I don't want us to go, I've been trying very, very, very hard, deliberately, to move away from a sort of politicking and the sort of hypocrisy that is surfacing in this matter. We must recall, sir, that even as far as 2015 and 2016, when amendments were being made in the Senate to the Maritime Drug Act and everything, that the then opposition senators, who are now part of this present government, that they called for divide and they voted against the amendments. They voted against the amendments, and the now opposition which brought the bill when they were government. They moved ahead to the Senate, and in, I believe, January 2016, the amendments to the bill were passed. So let us not go down this road of hypocrisy because the amendments to the bill, which includes the waiver, etc., was something that then opposition senators objected to in the Senate. But the bill was brought in, the amendments, and they were passed with the majority that the then government had in the Senate. So the records are there. So let us be careful and always be mindful of the fact that there is a matter that is before the court in the United States, and we don't want to do or say things to, one, discredit those proceedings or prejudice them, and also we do not want to give our foreign partners, remember these are our partners, we do not want to give our partners this sort of impression, because the world is looking on, and what we're saying now to our international partners is that we should never believe them when they indicate that 1, 2, 3, 4, 5 things happen in accordance with international treaties and international laws, and we must never believe them when they have indicated that we have that we have abided by the rules, by the treaties, we have advised persons of their rights and everything else, and we are observing these things. Because what we're doing here today, I don't know if it's bad politics. It's very, very bad politics, and it's bad optics, because we are saying to the rest of the world that Jamaica is prepared to, in a setting such as this, while a matter is in court, come and literally we're trying to tear up international agreements that have been in place for years, and we must be very careful, and we should stop it.
We should stop being so melodramatic. It's unnecessary. The issue, Mr. Chairman, is trying to get some clarity from the commando. And the reason why I asked the question is, go ahead, Ambassador.
If you'll allow me, Mr. Chairman, through you, just to respond to a question that Ms. Hannah asked the Commodore. The timelines are important. This is why we sought to put it under some headings. So the question you asked in relation to the what was now the outcome of the trial, where there was no evidence found brought to court then for the case. This was information that came, not that one? You said there was no.
Yes, you asked it earlier. Yeah. But say what question you asked.
I was asking a clarification from the Commodore. Is it Commodore, Commando, Mrs. Gorman? Commodore. I was asking if, when intelligence is given, does the Jamaican government rely on, without seeing the evidence for themselves? And she answered the question.
Mr. Chairman.
Yes, sir.
Commodore Weems Gorman started answering in a certain pattern. She realizes where she was going, or where she was being led, and she changed in midstream. Yes, she did. What it is telling me is that she is unable at her position to divulge certain information, Mr. Chairman, and therefore I am asking and I'm beseeching, I am imploring and bemoaning the fact, let us don't go down the road of trying the case here, lest we further prejudice or create a bias.
Well, Mr. Chairman, nobody is trying the case. The ambassador from the Ministry of Foreign Affairs was very clear that there are gaps too that they're trying to solve. My questioning has no desire to prejudice any case. That case is going on, and I was just asking basic questions for basic clarity, and the able lady has...
And also, Mr. Chairman, there certain questions are what we consider in law fact-finding. You cannot proceed without, so for example, asking about what evidence is there to suggest this, what evidence is there to suggest that. Those are questions which belong in the purview of a court of competent jurisdiction. We do not sit here as a court of competent jurisdiction. We do not have all the evidence or the facts before us. Neither are we in a position to lead from the persons there and present as to what exactly happened. And it really is in the interest, as a Jamaican, it is in the interest of those 4 fishermen. It is in the interest of those 4 fishermen that we stop. You want to know why? Simply because what we're doing here today is going to prejudice their case. we're prejudicing their case right now. We're prejudicing their right to a fair trial. That's exactly what we're doing now. We're prejudicing their case. And if we care about them, we should stop it.
Mr. Clark, you want to have an intervention? Okay, you wish to make an intervention. Okay, proceed, Ms. Anna.
Ambassador, there was in the Senate when the case broke, or the knowledge of the case, there was it almost seemed as if the ministry was not aware of the waiver. I remember specifically when Senator K.D. Knight asked a specific question. I think both ministries were giving conflicting information. Do you recall that?
I have to say, Ms. Hannah, that I don't recall the details of what might have ensued in the Senate. But if at any point there was an indication that we weren't aware of it couldn't have been of a waiver. It probably the entire making the correlation for this case being brought of the allegations of mistreatment in relation to a case where there was a waiver of jurisdiction over national. So I believe it would only have to be in that context of not making that correlation that we would say that we would not have been aware of the connection between the two. The case claim of allegations of mistreatment and a case of a waiver which now happened to be the same persons. So if there was any, I think it would perhaps be a misunderstanding and not a deliberate statement that we clearly didn't know anything.
Okay, yeah. Thank you.
Okay, no other questions, members. I think we'll close the discussions regarding the fishermen and what transpired there. The other outstanding is with the matter outstanding is with justice, not related to this, but rather, before I proceed. So both Ministry of National Security and Foreign Affairs, again, you can remain if you so wish. If not, you are permitted to leave. But maybe not Ministry of National Security, since the matter relates to national security. Essentially, it's related. The issues before the Ministry of Justice. In the discussions in the last meeting, the committee members, the main member happens not to be here today, who asked for the Ministry of Justice to be here, is the whole question of the backlog of cases in the courts and how that is, what efforts being made to clear those cases, and of course the delay in resolving cases, how they impact on the proliferation of crime throughout the country. So that is the background to why you were asked. So that's interesting that the member who posed the question and led the request was Member Green from Southwest St. Elizabeth. But you'll be here momentarily. Okay. It's 20 minutes after. So, PS, do you wish to take us through? You have submitted a report.
I'm sorry, Mr. Chairman. What's the final? Is Ministry of National Security allowed to leave? And for my part, thank you so much. I think, provided the reports are reported properly, the donation will be well advised, and would thank you for clarifications.
Well, as the PS member, Terrell, I can tell you, is well aware of how appreciative the committees are of the responses that she normally provides.
Yes, Chairman, thank you. Good
Now
morning.
that we have the foremost member of the committee who insisted that you be here, has joined us now, Member Green. Member Terrell, I don't want you to misinform or mislead your colleague. Madam Pierce.
His first comment to me was, I cannot believe the chairman of a committee is acting like the chairman of a political party in the committee meeting. He said he was very disappointed.
Mr. Terrell, you're in the parliament, you must not tell untrue stories there.
No, but it's interesting in front of the Ministry of Justice, and I'm glad the Ministry of Justice is here. Mr. Green, one of the things that the learned attorney said earlier is that in a court, it's a fact-finding mission. When the witness is present, they can actually give their own account of what was actually seen or said. Could you please provide your own account of what you actually said to Mr. Terrell a while ago?
Sure, let me apologize for being late. Hopefully my apology was tendered earlier. I'm very happy to be here. Thank you, Chair.
Because he didn't say anything that he said. Madam Pierce.
Good afternoon, Chairman. Good afternoon, members. Let me introduce the team that I have with me. To my immediate left is Dr. Donato Dennis, and he is the court statistician. And to his left is Mrs. Anne-Marie Cummings, who is the Principal Financial Officer for Court Management Services. And to her left is Ms. Teresa West, who is a legal officer acting. And actually it's Tressa West, legal officer for the Court Management Services. And in respect of the central ministry, I have with me the ministry CTD sitting immediately behind me, Mrs. Grace Ann Stewart McFarlane. I also have Ms. Karen Wilson, Director, Legal Services Unit, and Mr. Andre Kaur, Deputy Director of the Legal Services Unit at the Ministry. So, Madam Chairperson, a report has been submitted to the committee, and that report outlines the current stock of backlog cases in the courts, covering gross backlog case, which includes both active and inactive cases, and net backlog case, where inactive cases are subtracted. And a case in backlog is defined as a case which has remained unresolved in the courts over 2 years. And Dr. Dennis will be able to provide in great detail the information with respect to any explanations and clarifications as to what is a case in backlog, in the gross backlog and the net backlog category. The report also outlines the strategies being utilized in the courts to bring the backlog across the court system within international standards. So we agree that the current level of backlog remains high, but I want to highlight that progress has been made over the last 2 to 3 years to reduce this backlog, and that a number of initiatives are underway to continue the reduction of backlog and to bring it in line with international standards within the next 6 years. It's not a process based on the current level of backlog that you're going to be able to complete in a year. Just to also highlight that the progress towards this goal saw a clearance rate of 103.4% in the first quarter of this year, and a clearance rate of 108.45% in the second quarter of this year, meaning that for every 100 cases that were brought in as new cases, 103.36 would have been disposed during that period. So in other words, the court would have resolved more cases during the period than the cases that would have been filed during the period. So as a result, you can see that the backlog is beginning to be reduced as a result of having that kind of clearance rate. The Supreme Court website has the various quarterly reports which are produced every quarter with respect to to court statistics. And so there has been a move to total transparency because this data is now published quarterly and is a matter of public record. The report, in addition to outlining the overall current backlog, provides also the estimated backlog rate and absolute backlog counts in selected business lines in the court system. And as I said, it presents the strategies that are being employed in the court system to bring the rate in line with internationally accepted standards, and the internationally accepted standard is 10% of unresolved cases. So in other words, there should not be a backlog of more than 10%. And it is expected that we will attain those international standards based on the strategies being employed within the next 3 to 6 years. This is the vision of the Chief Justice. He's taken leadership in this matter, and he has spearheaded the development of a strategic plan for the administration of matters in the court and for the transformation of the Jamaican court system. In his words, to be the most efficient in the region within the next 3 years and among the best in the world within the next 6 years. And the report outlines a number of matrices that have to be achieved for this to happen. That includes an attainment of an average clearance rate of 130% and a hearing date certainty of 95%. Now, for comparison, the second quarter of this year was at 108%. The target over the period is 130%. There are several other initiatives that are being employed to reduce the backlog and improve the efficiency within the courts, and these are outlined as well in the report. This would include initiatives such as the employment of fast-track courts, improving the science used to schedule cases for court, chamber, and administrative hearings, to reduce the incidence of adjournments and improve trial date certainty, process flow re-engineering to improve the efficiency of case flow progression matrix across the different business lines, and so on. And just to say, Madam Chair, that I had the benefit of being at the judiciary retreat a few weeks ago, and how absolutely impressed I was to see judges spending half a day understanding the scientific data-driven methods that were now being brought to bear in terms of court management, and listening to Dr. Dennis as he informed on these matters and asking very relevant questions. So we're not accustomed to persons with a legal background looking at statistics and how to use data to inform action. So it was very, very impressive to see that happening. In addition to the work which is happening in the courts, which is the primary focus of the report which has been provided to the committee, I just want to highlight that there are other initiatives which are being undertaken by the ministry, which in fact supports efficiency in the courts and will also assist in reduction of backlogs in the court. So the court improvement, infrastructure improvements in the courts, such as the renovation that we have just completed of the Court of Appeal, inclusive of the increase of the number of courtrooms. More courtrooms you have, the more cases that can be scheduled, for instance. And also the action which is currently underway to provide an improved comprehensive case management system as well as the provision of audio equipment in 78 courtrooms and video equipment in 19 courtrooms. All of that will help to improve the efficiency of the courts and help to reduce the backlog. We are also, as a ministry, at the direction of our Minister Delroy Chuck, placing great emphasis on the establishment and expansion of an alternative disputes resolution framework, which again will help in diverting matters from the court to other mechanisms for resolution. So, for example, the ministry has over the last several years had in place restorative justice centers which have been handling matters in some instances referred by the courts. And I'm informed by Dr. Dennis that in fact a percentage of the backlog which has been reduced in recent times was as a result of cases that would have been referred to restorative justice, which his survey indicated had a 60 to 70% resolution rate. And the ministry will be expanding restorative justice during the course of this year and continuing into next year as the ministry moves to have a justice center in every parish which will offer both restorative justice services and child diversion. The committee will be aware that the Child Diversion Act 2018 was passed last year, and we are now, as a ministry, in the process of putting in place the infrastructure and the resources to operationalize the Child Diversion Act. We have been meeting with our partners, the Jamaica Constabulary Force, the Child Services and Family Agency, the Correctional Services, a number of entities who will work with us in ensuring that we can put the Child Diversion Act into operation, which will see that children 17 and under in specific instances being diverted away from action in the court and being either cautioned or put through a process of rehabilitation. So those are areas that the ministry will continue to push as we move forward. Legislative action has also been taken, which will also help to support the reduction of backlog in the courts, and my colleague from the Ministry of Justice can provide further information in respect of the legislative action if that is information which is of interest to the committee at this time. So, Chairman, that's a synopsis of the information you have in front of you and the additional and wider strategies and work being undertaken by the Ministry of Justice to support the reduction of backlog in the courts. And I am going to hand over to Dr. Dennis, who is the statistician and expert when it comes to the scientific data-driven methods being undertaken by the court to provide short comments and to provide clarification on the information contained in the report that would have been provided to the committee. Thank you.
Thank you very much, Pace. As I indicated earlier on, the background to our inviting you here today, from the data from the police, one of the clear indicators is that a lot of cases go unresolved for an extended period of time. Many persons convicted of crimes, violent crimes, they are logging in the courts for a very extended time. Many of these persons are involved in committing other crimes while they are out on bail awaiting trial and the disposal of these matters. And also the fact that the cases take so long to be disposed of there is not a sense either amongst criminal that there is a consequence that will flow from that criminal act committed. Because when a case is resolved 4 or 5 years after, there's no connection between the act committed and the consequence that flow from it. And two, the citizens themselves feel that criminals can commit criminal activities and there's no penalty to them. So they themselves feel that the society is not there to protect them. But you have provided some information in your written submission, and you have elaborated on it extensively this morning. So against that background, I don't know if there's any other question that my colleagues would have to ask from either yourself or other members of the team with you this morning. I'll give preference to my colleague from Southwest St. Elizabeth, and then Member Campbell.
Agreed. Thank you, Chairman. Firstly, I really want to commend the team from the Ministry of Justice. I want to commend you, PS, and the team led by Dr. Dennis. I am very impressed with the report, and it's a trend that we have been seeing, but I think it's information that has to be continuously shared. The fact that you can give me in raw figures and percentages where you are means that we not only have a target, but we're keeping track of what is happening. And I think what the public really wants to be aware of is that for years we've been talking about the backlog, talking about the issues, but that we're really treating with them now. And I do get that impression. And I like the fact that the target does not seem to have been pulled out of a hat, that you've given yourself enough time, you're not giving unrealistic pronouncements. I think that is very, very important. So I really want to commend the team, and I believe the fact that you're posting information online, we will have to again get the word out there, but I think this will restore some faith in our justice system. And the chairman spoke of the link right across. If people don't have faith in the justice system, it undermines the very foundation of our society. There are just two questions that I have. One, the 10% target in terms of the amount of backlogs, is that a target for criminal cases, or is it a target for the overall backlog? And I'll just go a bit further. We speak a lot about the criminal case backlog, which is critical and very, very important, which we all want to see go down, but I don't hear us speak as much about the backlog in the civil side of the law, which affects business, ease of doing business. Now, I'm not sure if because the cases aren't necessarily in backlog, they just have a long gestation period, but I'm not sure. So does that count the civil cases? I'll stop at that question, and then I have one more, Chair.
Yes. Thank you, Minister. So the 10% is an average backlog rate across all business lines, civil, criminal, family court, and it cuts across jurisdictions. So law court, parish courts, Supreme Court, Court of Appeal. At any given point, based on the international prescriptions, no more than 10% of all active cases should be in the system for more than 2 years. So the barometer that is used to define a case backlog, regardless of business type, based on the international prescriptions, is 2 years, which is considered to be a reasonable time, on average, to resolve cases regardless of the business line that it falls in. So it's 10% overall. If we were to narrow down the focus to criminal matters, the average prescribed, the maximum prescribed for criminal matters is actually 8.5% for criminal matters, right? So that 10% would have taken account of the, not just a simple average, but a weighted average, taking into account the relative proportion of cases from different business lines that would typically be in a court system. So it's an overall average figure.
Thank you. And my second question now, from the time that I spent interacting with the court process and the criminal court process, you recognize that a lot of the criminal case backlog seems to be caused by poor file preparation. Now, that doesn't fall directly under your remit, but at the end of the day, it is your ministry that will be asked to treat with the backlog. So I wonder if you have looked at strategies in relation to the file preparation, if you've picked that up as one of the big issues, if you've looked at strategies, and if you're working with the various other ministries like the Ministry of National Security in that regard and the police. And if so, if you could tell us a little bit about what is happening in that regard.
Right, so your point is quite spot on. In fact, one of the several measurements that we have devised, again guided by the international literature, in terms of tracking the efficiency of courts, is what we call the case file integrity rate. So the case file integrity rate, so if you have a look at the statistical reports, you will see that particular measurement reported on. What it basically measures is the proportion of cases which are able to proceed without being adjourned as a result of the file being not available or the file being incomplete. Now, the criminal court system overall has an average case file integrity rate as of today of about 78%, which means that 22% of cases would have been impacted using the last 3 years average by the file not being ready, which of course affects trial readiness. It has a negative impact on the trial date certainty rate and the time that the matter takes to be disposed from the court system. So that is a measurement that is of keen interest to the judiciary, the Chief Justice at the moment. And so many strategies have been deployed to engage. The courts have some responsibility as well, because the efficiency of management of the registries, the efficiency of management of cases contributes to the readiness of case files. And so right across the court system, we have now deployed case progression officers. So there are case progression officers in most courts, particularly in the criminal courts, but also in some civil courts. And the purpose of the case progression officers is really to help to piece the puzzle together, to ensure that documents outstanding, for example, from the medical services, from ballistics, from forensics, whatever other documents that are needed to complete a case file, that the waiting time for those documents are reduced. And this requires constant and robust engagement of the stakeholders. And so there is an aggressive effort in place as far as that is regarded. As I mentioned, there's an entire staff line that is committed to that, and the Chief Justice continues to lead discussions with the stakeholders, and the Ministry of Justice continues to play a significant role in engaging the stakeholders to ensure that they understand that when we say a case is in backlog and when we say a case is lagging in the court system, it is not simply a matter of the execution of judicial processes, because there are interlinks with these other bodies that I mentioned, which have to work seamlessly in order for cases to move efficiently through the court system. So there are active engagement of the relevant bodies, and the case progression officers are playing a critical role in this regard. I must mention as well that the courts have made considerable progress with the use of technology. And so this is one that is, as the Permanent Secretary mentioned, this is one thing that is aiding the ability of the courts to keep track of the cases and the delay factors that are contributing to particular cases lagging in the system. So the case progression officers have at their disposal a data system that is maintained by committed data entry officers across all courts in the island. And this system allows us to keep track of the cases from the womb to the tomb, as we would say, from the initiation of a case to the point that it is mentioned, adjourned, every event leading up to disposition, we're able to say what is happening. Repeat, please. Electronically, yes, electronically. And as the Permanent Secretary mentioned, we are moving even further to a more sophisticated system, which is expected to be in the courts pretty soon.
Okay, thank you, Dr. Dennis. Member Campbell.
Thank you, Chairman. Dr. Dennis, I note that in this Supreme Court civil matter, cases are being set now for...
Pull the mic a little bit closer.
I'm sorry. Cases are being set as far away as 2024.
Yes.
Against the background of the criminal ruling, which suggests that if a criminal convict, or not convict, criminal, an accused, man, if he has to await trial for 5 years, that it amounts to a breach of his constitutional rights. Is it your opinion that it amounts to a breach of the citizen's constitutional right to have to wait 5 years? This is after the case management has been dealt with in the Supreme Court. He has to wait 5 years thereafter before his matter reaches a judge. Albeit it may be set, the date is set as a certain date when the trial will take place. Because it seems a little bit odd to me that after case management that one should have to wait for 5 years to have the matter determined by a judge.
Yes. What I can speak to in direct terms is the mechanics of the policy that you mentioned. So I will clarify the mechanics and how it is intended to bring redress to the current situation as far as backlog is concerned in the courts, right? So you mentioned that some matters are being scheduled well into the future, right? Some matters as far as 2021, 22, and possibly further. Here is the intention. We have determined that one of the most critical factors that contribute to expediting the disposition and clearance of cases from the court system is the certainty of hearings and trial. So, as it's in the status quo, what obtained is that we have several dates being set for trial which are adjourned. This causes frustration, delay in case processing, and really diminishes confidence in the processes and the management of cases as undertaken by the courts. So we have determined that there's a strong correlation between setting multiple trial dates without certainty that these trial dates will proceed on schedule and the length of time that it takes for matters to be disposed from the court system. There's a strong correlation between the two. The current model that has been deployed by the Chief Justice to schedule cases into the future is based on what is scientifically estimated as the time frame within which, based on the current state of the case, the time frame within which the case is most likely to be ready to proceed. In other words, it is entirely conceivable that setting multiple trial dates and having multiple adjournments as obtained in the status quo may have delayed such matters in the court system beyond the certain date that is now being established as part of this new mechanics. So it is not going to be the new order of the day, let me clarify. It's not going to be the new order of the day to be setting cases way into the future. What is happening right now is that the cases are being set into the future in order to create a more manageable trial list, both in the short and medium term. What you will find over time is that the rate of disposal and clearance is going to increase over time because you're setting dates which are certain. As the rate of clearance increases, so there's no real quick fix, let's put it that way, right? It's a process. And so the current mechanism is going to ensure that within the next few years, the clearance rate would have increased so significantly that the trial lists and the hearing lists before the courts, before the Supreme Court and the circuit courts more generally, are far more manageable. That is the aim of the policy that is being undertaken now. So let us be clear that it is not the new order of the day. It is an intervention. It's an intervention meant to bolster our clearance and trial date certainty. Even though, admittedly, mathematically there might be a trade-off between the two in the short run, right? That you might have initially you might have a slight increase in the time taken, but over time, medium term, you're going to find that the clearance rate would have increased to the point that our trial lists are far more manageable and that the confidence in the court's scheduling processes would have increased. Because confidence is a real issue. If we're setting dates with the public believing that the matter is going to be adjourned, which is, we know has existed in the past, then what is going to happen is that you're going, it's almost like a self-fulfilling prophecy, right? So the dates are being set, people expect it not to happen, and so the necessary work to put in place from the external stakeholders, etc., is not undertaken with the level of venom that it should and expediency that it should, right? And so adjournments will inevitably continue. So this is an intervention that we are confident will ensure that within the next few years the courts have a much more manageable trial list, much greater guarantee that your matters will be concluded within a shorter space of time.
Would you say by 2025 we should have cases, if a case were to come up in 2025, within 2 years of 2025 that case would be tried?
Interesting that you have chosen that year, because that is exactly the strategy that is being laid out by the Chief Justice. So there's a fully articulated strategic plan around that 2025. So by that time we would expect to have a much more manageable trial list, much greater confidence in our scheduling process, and a much greater probability that cases will be concluded within 2 years.
Well, have you done any assessment as to what the level, if you were to increase the jurisdiction of the magistrates court, the civil jurisdiction of the magistrates court, let's say we were to take $2 million, just plucking a figure, how that would impact upon your ability to dispose of the cases in the Supreme Court?
We have not done any scientific assessment of that at this point, but certainly there are many issues to consider, including the capacity of the parish courts to manage the inevitable increase, quantum increase in caseload that would take place. So I haven't done any real scientific analysis of it, but what I can say based on the evidence that we have, we measure something that is called the case congestion rate. What the case congestion rate gives us is an indication of how overburdened a particular court is relative to its resources. So it basically gives an indication of whether the case, how effectively a particular court can manage its existing caseload. It's case congestion rate. The average case congestion rate in all courts across the island is over 100%. And across the entire court system, we're scaling 130% congestion rate, which means that on average, the courts are carrying 30% more cases than the state of resources and clearance would suggest that it can carry. So all of this would have to be considered. It's certainly something worth exploring in my humble opinion. But the capacity of the courts, the parish courts, to absorb that increased caseload, given that They are on average 30% over their capacity right now. It's something that would have to be given serious attention.
I take that point, but would you also consider, because I noticed that in the magistrates court, you have a system where clerks are still sitting there with carbon paper put between pages of summons, and they're handwriting those summonses for, and attorneys having to, and members of the public having to come there and wait for 4 weeks before they can get a summons to hand to a bailiff, who then goes on to service. Would you not consider using the same approach as you do in the Supreme Court, where it is lawyer-driven, instead of the court driving the process? Because if you were to use the same approach as in the Supreme Court, I would file my claim form, or whatever you call it, in the magistrates court. It is just, all it is just taken to the window, the appropriate fees paid. You get a stamp to acknowledge that it has come into the court, given back to the lawyer goes out and does what he has. Instead, it is being driven by the court, and it's, you know, as you say, you have 130%. With technology.
All right. Yes. So that's I think that's a very interesting point. Let me underscore something that we mentioned earlier. We recognize that as a deficiency. The heavy manual processes in especially the parish courts is something that we recognize as a factor that needs to be handled in order to increase efficiency. So let me say that the new case management system that I mentioned earlier will have the capability of automating the production of warrants, summonses, various court documents that are issued by the registry. That's exactly where we're headed right now, and we feel that is going to have a marked effect on improving efficiency. So a lot of these manual processes, those forms you mentioned, will be automated in relatively short order.
Okay. Thank you, Dr. Dennis. I think my colleague knew very well what the program was by the Chief Justice. The dates wasn't a coincidence. Thank you, PS, and to your team. We'll be in touch with you should we have any further clarifications coming out of this morning's presentation. Thanks. Colleagues, we need to set the agenda for the next meeting. I want to suggest that we could agree to arrive at that through a round robin through the secretary of the committee. It doesn't make sense for us to come here and spend a morning just to make a decision on something when we have the technology available to so decide. So if we can reach an agreement on that, we could forward our suggestion over the next couple of days to the secretary, and through email we come to a conclusion, and then we convene the next meeting accordingly. Those in favor? No, let me just take it one at a time. Those in favor of that proposal? Those opposed? Okay. Please note. I don't think he wants us to hear that.
Also, by the rules that govern the committee, Mr. Chairman, we must take a vote on the matters that we will ask to come before us.
That is what we will do via what we just agreed to.
No, you said to set the date for the next meeting.
No. I said to agree on the next item for the agenda. Okay, colleagues, with that, I now ask for put the adjournment. So adjourn.
Gallery Barrington has been around since 1974, with the first of 4 locations at Union Square in Crossroads. The gallery now only operates at 75 Hope Road in Kingston. Today, Let's Talk Art explores this wonderful establishment, as well as talk to the founder and owner. "My eye is my pencil, and my brain is my sketchbook," is one of the many quotes from his book, Barrington. Professor the Honorable Barrington Watson, OJCD, or Barry Watson as he's affectionately called in the art world, is the owner and founder of Gallery Barrington. Philosopher, teacher, soccer player are some of the terms used to describe him, but the one he prefers most is artiste.
I am Barrington Watson, artist. I think that's how I like to be known as, Barrington.